Committee on Insurance will come to order. The clerk will call the roll.
Chairman Oliverson.
Present.
Vice Chair Ann Johnson.
Here.
Representative Paul.
Here.
Representative Perez.
Here.
Representative Kane. Representative Julie Johnson.
Here.
Representative Hull. Representative Caroline Harris.
A quorum is present. Okay, so members, today it is the chair's intent to vote on bills as soon as we get off the floor this afternoon. So if everybody can just try to, as best as you can, not run out of gas before we get to vote, because we got a lot of members that are hoping to get their bills out of committee today that would like to be able to do. In the meantime, we're going to hear some very fun bills today. It's going to be an exciting day of fun stuff. The chair lays out Senate Bill 796, the Senate companion to House Bill 5144. The chair lays out a complete committee substitute, and the chair recognizes Vice Chair Ann Johnson to explain Senate Bill 796.
Sorry, I wasn't.
That's okay, I'm sorry. Are you ready? Do you want me to do something else?
No, I'm ready.
Okay, I'm sorry.
Julie's got something started going.
Thank you, Mr. Chairman, members of the committee, for allowing me to lay out the committee substitute for Senate Bill 796 before you today. Arbitration may be used to settle insurance disputes between insurance providers and policyholders. The arbitration process is intended to provide a quicker, less costly method for resolving a claim than litigation. Concerns have been raised that supply line insurance policies do not have the same protections extended to consumers in standard policies within the admitted market. Surplus lines, policies are not regulated or reviewed by TDI, which has allowed some carriers to write arbitration provisions that are harmful to the consumer. For example, many surplus line policies call for arbitration in New York. It makes no sense for Texas property owners to have their claims resolved in New York under New York law. This burden makes the arbitration process more expensive, cumbersome, time-consuming, and dissuades policyholders from seeking a better outcome. Furthermore, for many claims, the statute of limitations for breach of contract and property damages in New York is 1 year. In Texas, it can be up to 4 years from the time that the insured's cause of action accrues. When arbitration is sought, committee substitute for the Senate Bill 796 requires that the arbitration be conducted in Texas and governed by Texas law. It also requires that the insurance contract be interpreted in accordance with Texas law. There was this committee substitute in the Senate, which simply clarifies that the arbitration must be conducted in Texas if the surplus lines insurance contract is related to a risk-located entity in this state and would apply to a contract entered into in or outside of this state. Thank you, Mr. Chairman and members. I believe there are some witnesses that are registered to testify, and I reserve the right to close.
Thank you, Vice Chair. Members, any questions for Vice Chair Johnson? Okay, we'll reserve your right to close. At this time, the chair calls Mr. Jeff Reisner. I have you as Jeff Reisner, testifying on behalf of yourself, and you are for the bill.
Yes, members of the committee, good morning. My practice involves the representation of commercial and governmental clients in complex insurance recovery disputes. To give you an order of magnitude on how common these out-of-state arbitration provisions are, over the past 2 years, I've represented 9 different school districts in our state. 8 of those policies contained out-of-state arbitration provisions. 6 of them required the application of New York law. There are 3 common features in these that the bill addresses, and I think are imperative that all of these features are addressed. First, the application of New York law. Second, a New York venue. And third, the requirement that in the policies that the parties apply to a New York court to address any disputes concerning the arbitration agreement. These all work in tandem, and here is why this is a particular concern. Vice Chair, you mentioned the 1-year statute of limitations. Thank you for referencing that. In particular, that can result in a situation where parties are working in good faith on a complex matter to try to resolve it. That can take an extended period of time. If that goes beyond a year, they learn that their matter is no longer able to be pursued. That's demonstrably unfair. To compound that problem, New York law provides some extraordinary powers for arbitrators and courts. They allow arbitrators to disregard another state's law in favor of New York law. They allow arbitrators and courts to pause an arbitration and enforce a statute of limitations. They allow New York courts to hear and address matters related to an arbitration simply because the arbitration takes place in New York. So it's imperative that all of these features be addressed. This is by design. This is not an accident. Over the course of my representation, in a matter involving the primary proponent of this arbitration policy, a managing general agency called AmRisc, we have found some documents. They are confidential. The court's authorized me to provide them to the committee for legislative purposes. It is clear that in 2010, this policy was put together, and the proponents of it specifically designed it to trick policyholders and brokers into not seeing these. Many of the quotes and binders do not reference these out-of-state arbitration provisions, so the trick of including it is not disclosed to most policyholders. I think I'm out of time, but I'm happy to answer any questions.
Members, any questions? Representative Kane.
So you're saying these are contracts with government entities, and the government, is it cheaper for us to go to New York?
No, it's not. It is exceedingly expensive. To give you a specific data point, several of them, in my experience, New York arbitrators charge between $1,000 and $1,500 an hour. To give you one specific example, in a matter I'm currently handling, my client, which is a school district, proposed a former Texas Supreme Court justice. Everybody here knows this former Supreme Court justice proposed that person to serve as the neutral chair of the arbitration. The opposition proposed a New York judge that cost twice as much as a former Texas Supreme Court justice to resolve the dispute. When we go there, it can cost tens of thousands of dollars a day, not only with the increased costs of the arbitrators, but with facility fees and travel and bringing witnesses to New York.
All right, thank you. I think it's a great bill. Thank you.
Thank you.
Jeff, I'm curious, so not being an attorney myself, what is it about New York law that they find favorable? I mean, is there a reason why they would prefer New York law over Texas law, other than it's sort of their backyard and so it's, perceived to be more friendly venues? Is there something peculiar in the insurance code there that makes it favorable to a surplus lines carrier?
There is, and first off, part of it is that ability to reach out and grab matters from other states and apply New York law. So if you come within that jurisdiction, they are by statute authorized to apply New York law. New York law, of course, contains the one-year statute of limitations that can be enforced contractually, even if Texas would not permit that, and Texas does not permit that. The minimum is 2 years. So that's another significant feature. And there are damage limitations, basic things like attorney's fees and interest. Forget about punitive damages. Attorney's fees and interest are generally not recoverable in money.
May I ask, and again, just my ignorance, not being an attorney, but you mentioned school districts. I'm assuming school districts have attorneys that are licensed to practice law in the state of Texas. Are there, if you have to do an arbitration in New York, do you find yourself having to get somebody from New York, or can you bring your attorneys from out of state? I mean, how does that work typically? I just need a little education.
Yes, you can bring attorneys from out of state to handle an arbitration in New York.
Okay.
Part of the problem is they will apply to a New York court, and then you need a New York attorney to deal with some of the panel formation issues that they will.
So they have you at a disadvantage automatically because your legal representation is limited in its ability to represent you in a foreign jurisdiction.
That's right. That's right. And
Well, it's a great bill, and I appreciate you being here to educate us on it. It is interesting to me as the chair of this committee that, in my experience with NCOIL, I've noticed through the years that New York likes to assume that insurance law of each state applies only to that state, except for the state of New York, and their insurance law should apply to all 50 states. That's sort of the joke that we hear at the
And it is
national level.
precisely accurate, yes.
Well, thanks for being here today,
Thank you very
Jeff.
much.
The chair calls Mr. Jim Beneke.
Good morning.
Good morning. I have you as Jim Beneke representing the Texas Association of Public Insurance Adjusters and yourself, and you are for the bill.
Yes.
All right,
thank
please
you.
share your testimony.
I am chairman of the Government Relations Committee for TAPIA. I'm here to speak on behalf of TAPIA today, and we're in favor of the bill. Historically, when there is a disagreement about the amount of a property insurance claim, policies have provided for appraisal to resolve that dispute. Excuse me. Appraisal is intended to be an expeditious, inexpensive process to resolve a claim without litigation. In the surplus lines market, there is a trend to substitute arbitration for appraisal to resolve the dispute, actually to resolve any dispute in the settlement of a claim. In many cases, the arbitration is required to take place in New York and under New York law. As you might imagine, arbitration in New York is anything but expeditious and inexpensive. Not to mention that a Texas policyholder shouldn't have to go to New York to resolve their property insurance claim. Generally speaking, TAPIA believes that appraisal is a better method for settling a dispute over the amount of a loss. However, we're not here to say that surplus lines carriers can't offer arbitration if they feel that's what's best for them. But we believe that arbitration should be held in Texas under Texas law if that's the method that they choose. This is a consumer rights issue. Most consumers have no idea that they might be faced with arbitration in New York if they have a dispute with their carrier. When they learn of the time and expense required to complete the process, many will choose to simply forego it and accept what the carrier offers them, whether it's adequate or not. Requiring arbitration to be held in Texas doesn't solve everything in the dispute resolution world, but it's a great start. Happy to answer any questions.
Members, any questions for Mr. Beneke? Jim, thank you for being here today. Appreciate you. At this time, the chair calls Mr. Jay Thompson. I have you as Jay Thompson, and you are representing WSIA. Is that right?
That's correct.
And you are neutral on the bill.
I am.
All right, please share your testimony.
The WSIA is an entity called the Wholesale Specialty Insurance Association. The name was changed as a result of a merger of two very large national organizations, one of MGAs, the other of surplus lines insurers and brokers. And the concern here is not so much on arbitration for home state. We've amended Texas law to define home state for an insured to be consistent with federal law. In the home state, most surplus lines are very large businesses. We've amended the law to allow a very large business, it's called an exempt commercial purchaser, to not have to go to the admitted market first before they buy surplus lines. Surplus lines policies are typically not regulated, and when they are, it would be the home state that could do that. The bill that came over from the Senate has some language that I think would be inconsistent, that would not resolve litigation, because it talks about not allowing arbitration clause, or it allows it, but it's got to be construed under Texas law if the risk is solely in this state. I understand that from the standpoint of, we've heard the story of the Corpus school district that bought a policy. They didn't know there was a New York appraisal clause in it. I think the agent may have misrepresented the MGA to maybe the local agent that. And so we have suggested some language. I've been working with Craig Island and Representative Johnson's office that would do two things. Number one, it would make it clear that this is for residential property risk located in this state. The bill that came over just talks about risk. You could have a liability policy where you're not negotiating an appraisal clause. That only applies to first-party type property losses. Second point is that a large risk ought to be able to negotiate both the choice of law that they want in an arbitration clause. You could have a large risk that's principal office or home offices in Texas, but they may have locations all over the world. And in order to qualify for that, they have to have a qualified risk manager on their team. And in Texas, the freedom of contract should be maintained on that key point. And those would be what we would ask for. I mean, I think that I fully understand that individuals who buy an individual surplus lines policy, this law that would apply to them, they would be Texas their home state. Texas laws should apply. They shouldn't be asked to go to New York or anywhere else to do an arbitration if it's in there. But large commercial risk ought to have that freedom. There was a Texas Supreme Court decision on Friday that came out that reaffirmed that right of parties to contract. They were large risk and to contract who's going to determine disputes. So I've given that language to Representative Island both to look at in your office. I hope the committee will consider that. I'd be happy to share that with you as well.
Okay, Jay, I'm curious, so I understand if you have a large Fortune 500 company that may not be domiciled in Texas or doing business in all 50 states, that's not an unreasonable burden. But if I heard you correctly, you're talking about just residential policies?
No.
Or are you talking about, like, what about the school district? What about the city? What about the commercial policy for a business that's a completely domiciled in Texas business? I think that they shouldn't have to travel to New York.
This law would apply to them and would require them to have Texas as their choice of law for an arbitration provision.
Okay.
If it's their home state. So
Right.
home state's a defined term in Chapter 981. Now, governmental entities do fit that definition, and this a governmental entity that does not want a New York deal, the language I've drafted requires them to give their written consent beforehand. That solves some of the abuses of an MGA representing to a local agent that there's no arbitration clause or it's New York, and then come to find out when they get the policy several months later that it's in there, and then play hardball with it. I think requiring the written consent, that would also give your cities, school districts, if they want to negotiate an arbitration clause or not, they would have that same freedom. And if there's an arbitration clause, they would have to sign it in writing. So that's the language that I've suggested as a potential to solve the specific abuses that I've seen and heard about.
Okay. Members, any questions for Mr. Thompson? Okay, Jay, thank you.
Thank you, Mr. Chairman and members.
At this time, the chair calls Mr. Ware Wendell.
Good morning, Mr. Chairman.
I have you as Ware Wendell, Executive Director. You are testifying on behalf of Texas Watch, and you are for the bill.
That's correct.
All right, please share your testimony.
Thank you, Mr. Chairman. Members, this is a balanced bill. It's a simple bill. We generally disfavor arbitration clauses in insurance policies. We fought against that at TDI successfully under Commissioner Maddox, but there are some arbitration clauses in surplus lines policies. They have a different form of regulation at TDI. And so where there is arbitration in the policy, we want to make sure that that happens in Texas, that we're not just enriching a bunch of New York arbitrators charging $1,200 an hour, $1,500, God knows how much, making the parties travel, and that Texas law applies. So when it's a Texas dispute, let's keep it in Texas, make sure Texas law applies. That's good for the homeowner, who has a surplus lines policy, all the way up through the business owner, the school district, you name it. With that, I'm happy to take any questions, but I know you have a very full agenda, Mr. Chairman.
Members, any questions for Mr. Wendell? Where we thank you for being here again today.
Thank you.
And
I will see you soon.
We'll have your reserved seat for you here
Thank
today.
you.
I know you'll be testifying a lot.
I appreciate it. I
All
told
right.
Scott, Thunderstruck is my ringtone in case you're still taking nominations for walk-up.
That's
music, so.
actually a pretty fun one to learn to play on guitar.
Yes,
actually. It just,
for
your
sure.
fingers have to move really fast, so it can be
You know.
challenging.
We all want to be
My son
Angus.
can do it.
Yes. Thank you.
At this time, the chair calls Mr. Craig Island. I'd have you as Craig Island, representing Texas Trial Lawyers Association and yourself, and you are for the bill.
Correct.
And I would point out that you're also the former president of NCOIL, as I recall.
Yes, I am. Yes, sir.
But not testifying in that capacity. All right, please share your testimony.
Thank you, Mr. Chairman and members. I became aware of one of these provisions when I represented a hotel owner on Galveston Island after Hurricane Harvey. And I found this provision of the policy. Neither the hotel owner nor the agent knew about the existence of this New York arbitration. And I went, this can't be right. You can't enforce this. But I found out they could. And that's when I came up here, and we passed this bill out of the committee last session. And so I appreciate Vice Chair Johnson and Senator Middleton bringing it back this year. And while I will work with Mr. Thompson and others on the bill, I have a big concern about allowing contracting around. If we had businesses up here clamoring to give away their rights and their protections under the Texas Insurance Code, that'd be one thing. But what we have is insurance companies wanting the ability to force this on governmental entities. I don't think any governmental entity should even be authorized or allowed to contract away their rights under Texas law and have an arbitration subjected in New York. Some city council, some school district, they should not be allowed to do that with taxpayer dollars and taxpayers' money. I was the author of Chapter 981, or at least the provisions that Mr. Thompson was talking about with regard to large exempt entities to be able to go to surplus lines without being denied. I don't know that those risk managers that are referenced in that bill are qualified to understand the rights that they are contracting away when they agree to New York law with New York arbitrators. And so I say I would recommend the committee, let's pass it as it is with no exemptions. And if businesses come to us next year and say, we really want the right to give up Chapter 542. We really want to give up the right to recover attorney's fees. We really want to give up the right to recover interest. We really want to go to New York and stay at the plaza and spend some taxpayer money or corporate money to have a good time and arbitrate with excessive arbitrators. So if we have businesses come up here next session and clamor and bang on the table for that right, I'll be right here with them saying, okay, they want it, let's let them have it. But I think we can go 2 years and see what happens, get 2 years of cycle and see what happens and see if everybody's clamoring to be forced to go to New York under New York law.
So, quick question, Craig. Is it your feeling then, or your observation, because I think I kind of heard this from some of the other witnesses, it sounds to me like part of the issue here is that this is sort of open your presents on Christmas morning and realize, oh, you won the New York Arbitration Clause prize. So is there a failure on the part of policyholders and agents to essentially educate? I mean, do you feel like there's an intention to sort of slip this in a way that hopefully nobody notices?
Absolutely, absolutely. If you look at the information Mr. Reisner sent you that was developed in the litigation, it was absolutely designed to trick local agents and insureds because they get, if you do an RFP or even if you just get a proposal, the New York arbitration language is not in the document you get. And it doesn't catch up and you don't know about it until after your policy's been in effect and you get the actual 300-page policy. It's not in the decision-making documents that you get. And that's, if you look at the information Mr. Reisner sent to you, that was designed on purpose.
Okay.
And so
I think that's a really important point, that this is, sometimes people just don't know, but
Right.
when there's an intent to conceal information from somebody, I think that raises my antenna.
Correct, and it's absolutely, and a lot of the industry doesn't do this, but there are a few brokers that designed it and developed it and slid it in, and it's gone way too far.
Okay. Members, any questions for Mr. Island?
I would
Okay.
just add to close that, the large exempt commercial people, they need to, I've already said it, so,
Okay.
yeah.
It's great to have you back.
Yep,
Good to
good
see
to be
you.
here.
I hope you have a good day today, and hopefully we'll see you testifying again here in a little bit.
I think so.
All right. Who else do we have? Who? The chair calls Mr. John Schnauz. I have you as John Schnauz, representing the National Association of Mutual Insurance Companies, and you're against the bill.
Correct.
All right, please share your testimony.
First, I'm trying to get over the fact that Jay Thompson can run faster from a Senate hearing than I can back here, but
Are they working today?
they are very hard and quickly.
Not as hard as we are.
No comment, Mr. Chairman. We do respectfully oppose the bill. I think my comments are largely duplicative of Jay's, although I missed some of Jay's getting back here. I think the only points I would make for the committee, if they haven't been made already, is do keep in mind what the surplus lines market is there for. It is a safety valve on the rest of the market. There are many contractual provisions in surplus lines policies that the department would not approve, frankly, if they were put in other policies, and that's kind of the way the market is supposed to work, to be honest. It is a way to place hard-to-place risks and to allow more contractual flexibility there. As to the point about large commercial risk, we do think some exclusion for those is appropriate. Large commercial risks, frankly, outside of the insurance contract or outside of the insurance context, contract for applicability of other state law and other venues all the time. And so in that respect, some category of those would be an appropriate carve out, we think. Understand the concern for residential and for public entities. So that's all I have. Happy to answer any questions.
All right, members, any questions for Mr. Schnauz? John, we appreciate you being here as always, and we'll save your chair for you too. But apparently you can't have Thunderstruck because that's already spoken for. To find a new song. All right. Members, we do have TDI available as a resource witness if anybody would like to hear from TDI on the issue. Okay. If not, is there anyone else wishing to testify on, for, or against Senate Bill 796? If not, the chair recognizes Vice Chair Johnson to close.
Thank you, Mr. Chairman. I appreciate the thoughtful testimony from the witnesses. Ask this committee's favorable consideration of the substitute, and I close.
The chair withdraws the committee's substitute. If there is no objection, Senate Bill 796 will be left pending. Is there objection? The chair hears none. Senate Bill 796 will be left pending. The chair recognizes that Representative Caroline Harris is with us. And at this time, the chair lays out House Bill 340. The chair lays out a complete committee substitute. And the chair recognizes Chairwoman Thompson to explain her bill.
May I do it for me?
Yes, ma'am. Absolutely.
And you know, this is my second time coming for this good piece of legislation. You just ought to pass it without explanation. But I want to give you some information about it anyway. Mr. Chairman, I know that Texas has long recognized that children and adults have a different criteria for mental health diagnosis and services. However, as the insurance code is currently defined, many children under the age of 18 with behavioral or emotional issues do not meet the criteria for a serious mental illness diagnosis. Here's what is happening now. According to the Texas Hospital Association, about 60% of Texas youth entering the juvenile justice facilities have a moderate to severe mental health issue. High school students with symptoms of depression are twice as likely to drop out, and children who experience multiple traumas are 30 times more likely to have behavior and learning problems. A study done by the Meadows Mental Health Policy Institute also revealed that there are over 500,000 youth with diagnosable serious emotional disturbance in Texas. Approximately 30,000 of those youth end up in the schools to prison pipeline. Those serious emotional diagnosed kids, is specific to children and is already statutorily defined in education, juvenile justice, and child welfare. Although most health plans currently cover children's mental health services, some children still face barriers in accessing care due to the definition of serious mental illness. This bill will close that gap by clarifying the current definition of serious mental illness in the Texas Insurance Code to include a serious emotional disturbance for children, requiring insurance coverage and requiring a one-time study on the accessed benefits. Mr. Chairman, I have a committee substitute, and the substitute incorporates changes requested by the Texas Association of Health Plans and Texas Department of Insurance. It aligns definition of serious emotional disturbance with the substance abuse and mental health services definition. It removes the plan exemption, and it extends the one-year study deadline from August the 1st to 2024 to December the 1st of 2024. Members, our children have experienced a lot of loss and trauma. I think all of us are aware of that. The experience have been compounded by the pandemic, aftermath, school shooting, bullying, and on and on and on. Struggles have exacerbated the mental health issues that they have encountered. So why wouldn't we want to keep our children in their homes, out of the school to prison pipeline, or worse, from hurting themselves or others? This coverage can help children and their families before their mental health and functioning gets progressively worse. And I know that this committee agrees with me, Mr. Chairman. This is an extra piece of legislation, and it will do the job. So I would like to, I'm available for questions of this wonderful committee, and I would like to reserve the right to close.
Yes, ma'am, we will absolutely reserve your right to close. Members, are there any questions for Chair Thompson?
Thank you, Mr. Chairman.
Thank you, ma'am. The chair calls Ms. Christine Bryan. I have you registered as Christine Bryan, representing the Clarity Child Guidance Center, and you are for the bill.
That is correct.
All right, please share your testimony.
And we want to thank Chair Thompson for sticking with us. We wholeheartedly agree this is a fabulous bill. My name is Chris Bryan. I'm the Vice President of IT and Public Policy at Clarity in San Antonio. Clarity is a children-only nonprofit psychiatric hospital. And when you get your packet on the second page, if you look on the back of the second page, you will actually see the mental health code as written. And that is serious mental illness, which Chair Thompson defined. It is adults only. It only pertains to 18 and older. There is no code specifying coverage for kids. And the big difference is that for kids in serious emotional disturbance, it's about the functionality component, right? Because we know kids don't have the resilience or the maturity of the coping skills when they have a traumatic life event or something adverse happens to them. And Lord knows we have seen a lot of that over the last couple of years. So if you look at that list that's currently there, you can see that doesn't even really relate to kids, and it doesn't really make sense. Kids may need interventions that are related to their family environments or to at-risk school behaviors, which we're having a lot of conversation about this session, obviously. We're doing a lot this session with children's mental health. This is an easy one. This code already exists in Medicaid, in CHIP, federally, child welfare, juvenile justice, education. It just isn't in the commercial code. I want to make the big point that most insurers do this, and I understand this sounds like a mandate, but we're talking about the outliers. And at Clarity, we do see those outliers where they do not have the mental health coverage for the inpatient treatment that they need. And so this gives our families that parity protection, and we have done a lot of work on mental health parity to medical. So this will give us something that we can point to and help our families fight to get for the coverage that they need. So I just want to remind this committee that just like medical health, mental health, in mental health, kids are not little adults, and they have their own classification as well. So I'll take any questions.
Members, any questions for Mrs. Bryan? Christine, thank you for being here today, and thank you for your work with our kids. At this time, the chair calls Mr. Blake Hudson, who definitely needs walk-up music.
I'll walk up to whatever music Representative Thompson wants me to walk up to. We are neutral on the bill today. Blake Hudson with Texas Association of Health Plans.
Oh, yeah, let me do my thing. I have you as Blake Hudson. You are representing the Texas Association of Health Plans, and you are neutral on the bill.
That's correct, and I'll be very brief. So we had some concerns about the definition in the bill, and we were able to work with the author's office to get that changed. And I think, like Chris said, this is pretty broadly covered, but we wanted to make sure that there was consistency in definitions, and we were very happy to be neutral today and take any questions.
Wow, how come I don't get that on my bills?
Well, I think we can get there.
Members, any questions for Mr. Hudson? All right, we'll see you soon.
Thank you.
At this time, the chair calls Mr. Greg Hanch. I have you as Greg Hanch, representing the National Alliance on Mental Illness of Texas, and you are for the bill.
That's right, Mr.
All right,
Chairman.
please
Thank
share
you.
your
My
testimony.
walk-up song will be Kashmir by Led Zeppelin.
No, that's mine, so you can't
Oh,
have that.
darn. It's Chase Utley's, actually, from the
Okay,
Phillies.
I'll give you that one.
Texas has made extraordinary progress on mental health and substance use disorder parity. That is to say that we have a strong statutory framework for ensuring that treatment limitations for mental health conditions and substance use disorders are comparable to and applied no more stringently than those for medical and surgical conditions. Texas is increasingly seen as a model in this key area of the law. The health plans in Texas have been proactive in updating their policies to ensure compliance with our state's parity law. The health plans have been at the table as Texas stakeholders put together one of the only mental health condition and substance use disorder parity strategic plans in the nation. One of the gaps that has been identified in the law is that parity protections don't apply directly to serious mental health conditions for children. It is my understanding that most health plans are generally already offering this coverage. I suspect they are also likely applying parity analysis to coverage for serious mental health conditions among children. But there is no law in the books that directly applies parity requirements to this type of coverage. Just as the legislature has created serious mental illness coverage and parity protections for adults, we should have serious emotional disturbance coverage and parity protections for children. Thank you for the opportunity to provide testimony in support of the bill.
Members, any questions for Mr. Hanch? Okay, and so what was your walk-up music?
Kashmir by Led Zeppelin.
No, you can't. I said you can't have that.
Okay, I'll think of a new one.
But you're going to, so do you have a new one?
Heartbreaker by Led Zeppelin.
Okay, that's a
Big
good
Zeppelin.
choice.
Yeah,
Well,
all right.
yeah, okay,
deal.
we got you. All right, that I show as the last registered witness for this bill. Is there anyone else wishing to testify on, for, or against House Bill 340? If not, the chair recognizes Chairwoman Thompson to close on her bill.
Mr. Chairman and members, thank you for allowing me to present this bill. The last time I presented, this committee voted it out on April the 16th of last session. Of course, it took a slow vote at the China in committee, and I mean in Calhoun's committee, and died. I hope that's not the case this time. I hope that the House is going to be able to pass this one.
Yes,
We've made the right changes, we hope that. But you can vote it out now if you want to.
Well, we could, but we haven't done that all session, so that kind of creates.
You can make an exception. Mr. Chairman and committee members, thank you.
Thank you. The chair withdraws the committee substitute. If there is no objection, House Bill 340 will be left pending. Is there objection? The chair hears none. House Bill 340 will be left pending. At this time, the chair lays out House Bill 3188. The chair lays out a complete committee substitute, and the chair recognizes Chairman Bonin to explain his bill.
Good morning, Mr. Chairman and committee members. Thank you for allowing me to lay out House Bill 3188. House Bill 3188 deals with biomarker testing, which has become a crucial aspect of medicine, which enables doctors to use patient-specific genetic information to make a better diagnosis, establish a better prognosis, and actually inform specific treatment decisions for cancer and some types of rare diseases. Currently, health insurance coverage of biomarker testing is rather sporadic, and it is not consistently reimbursed. This legislation establishes guidelines that require health plan issuers to provide coverage for biomarker testing when it's supported by medical and scientific evidence, including FDA-approved or indicated tests, national coverage determinations, clinical practice guidelines, and consensus statements. The committee substitute is agreed-upon language that modifies the bill's applicability section by removing church benefit boards, 3-share premium assistance programs, and local government code benefit offerings. Finally, the health plans are only required to provide coverage when biomarker testing offers clinical utility. In other words, it's actually going to make a difference in the care of the patient. This means it must be evidence-based, scientifically valid, outcome-focused, and predominantly address the issue for which the test is ordered by a physician. These new coverage requirements will apply to those covered under the state's health plans, including ERS, TRS, and Medicaid. Happy to answer any questions.
Members, any questions for Chairman Bonin? All right, we will reserve your right to close. I know we have a few witnesses. You're popular today, so we'll proceed to testimony. The chair wants to recognize that Representative Hull is present. At this time, the chair calls Dr. Donna Hansel. I have you registered as Dr. Donna Hansel, and you are testifying on behalf of the University of Texas MD Anderson Cancer Center, and you are neutral on the bill.
Yes.
All right, please share your testimony.
Yes, thank you, Chairman Oliverson and members of the committee for allowing me to be here today to testify. On behalf of MD Anderson and those patients that we serve, I would like to thank Dr. Bonin for proposing this legislation to provide coverage for biomarker testing. As he has noted, the use of biomarkers is a critical tool that we use in pathology to make an accurate diagnosis, but also to direct patient care and patient monitoring of disease. Essentially, testing for biomarkers, which are biological molecules that you find in the blood, in tissues, et cetera, is really important for us to figure out the right treatment for the right patient at the right time. And so for those of us in cancer care, as well as those of us taking care of patients with other diseases, biomarker testing is essential for the work that we do in providing good patient care and good patient outcomes. Over the past several years, we've seen a huge increase in the development of new targeted therapies for specific cancer types and diagnostics that help determine benefits from specific therapies. From my own perspective at MD Anderson, we've seen a 50% increase in targeted tests and molecular tests that are being requested since 2016. We see nearly 200,000 unique patients annually and have up to 2 million outpatient visits a year. As personalized cancer therapy becomes a more standard approach to care, based on the diagnosis of an individual's specific cancer, biomarkers are an essential component of pathology diagnostics, care plan development and delivery, patient monitoring, and patient management. Thus, standardizing coverage for tests that are clinically relevant, supported by medical and scientific evidence, will minimize the impact of out-of-pocket costs for patients and ensure the most appropriate treatment is delivered. Again, we're emphasizing the best possible outcomes, fewer complications for patients, and lower healthcare costs over time. Thank you, Dr. Oliverson, for this opportunity to present.
Members, any questions? Vice Chair Johnson? Yep.
As one of the people that is still here and living a wonderfully healthy life because of MD Anderson, I just want to thank you for being here. So thank you.
Thank you.
You're welcome.
Members, any other questions? Doctor, thank you for being here today. We appreciate you.
Thank you.
At this time, the chair calls Rebecca Munoz. And I have you as Rebecca Munoz. You're testifying on behalf of yourself.
Correct.
And you are for the bill.
I am, yes.
Please share your testimony.
Good morning. Thank you, Mr. Chairman and members of the committee. My name is Rebecca Munoz. I live right here in Austin, Texas. I'm here urging this committee to advance Representative Greg Bonin's Texas Biomarker Testing Access Bill 3188. I stand here before you today thanks to biomarker testing. In 2017, at the age of 29, I was diagnosed with stage 2 triple positive breast cancer, an aggressive cancer that is highly responsive to targeted therapies found through biomarker testing. At that age, I had no idea how to navigate the health system and what actions to take. I thought my diagnosis was a death sentence, as four of my family members before me who were diagnosed with cancer did not survive their disease. Thankfully, the care team that I had advocated for biomarker testing, and I was able to get the targeted therapy that I needed for treatment. Right now, as it stands, I know not everyone is so fortunate. I had a complete pathological response to my treatment regimen, and I celebrated my 5th year of being no evidence of disease this past March. I credit that entirely to the access to biomarker testing that I was able to have. As a breast cancer survivor and advocate, I have seen firsthand the devastation that this disease can cause. If I didn't have access to biomarker testing when I did, I cannot say for certain that my outcome would have been as favorable. Biomarker testing creates a foundation for better health outcomes for those affected by cancer and beyond. I thank you for your time and attention today, and I hope to count on this committee to advance this bill and create better futures for Texas and their families.
Thank you, Rebecca. Members, any questions for Ms. Munoz? Thank you for being here today. Thanks for sharing your testimony. At this time, the chair calls Dr. Lisa Trevino. I have you as Dr. Lisa Trevino, and you are here on behalf of DHR Health Institute for Research and Development and yourself, and you are for the bill.
That's correct.
Okay, please share your testimony.
Good morning, Chair Oliverson, Vice Chair Johnson, and members of the committee. Thank you for the opportunity to testify today. My name is Dr. Lisa Trevino, and I currently serve as the Vice President for Clinical Research Operations at the DHR Health Institute for Research and Development, and we are located in the Rio Grande Valley. So I'm here again to testify in favor of HB 3188 and also on behalf of the patient community at large, and I'm very humbled to be with my fellow witnesses that are cancer survivors here. I have a doctorate in molecular and cellular and developmental biology with an emphasis on the genetic and genomic landscape of not only cancer, but other diseases as well. So I find it quite timely that we're all here today. It's been 20 years since the fully sequence of the human genome was published. What took 10 to 15 years and hundreds of millions of dollars can now be accomplished in a matter of hours for under $200. I think we've been able to massively revolutionize the way in which diseases are detected, treated, and hopefully prevented with the discovery made from the sequencing of the Genome Project and also the identification of biomarkers. As we've just heard, it's been able to enhance and increase the lifespan of patients from many different diseases because we've been able to identify those areas in the genome that are enriched in these diseases and thus target them effectively. This is also very, very important for those families that have gone undiagnosed for many years without a clinical diagnosis and with the complete and thorough sequencing and identification of biomarkers in these really clinically mysterious diseases that some of the patients come forth with, they can have some identification of the etiology of their diseases. Biomarker testing is minimally invasive, as we know. It's a simple blood draw, a buccal swab collection, and as such, that is going to then further encourage patients to be willing to have these assessments done. We all know that there's a paucity in data coming out of several underrepresented minority groups because they're afraid to take part in larger interventional studies. Biomarker testing allows for that also to be accomplished, for the findings to be accomplished with sample testing, identification of those biomarkers that you could then really ideally identify through long-term, many years of being in a study. Not only has biomarker testing made its mark in oncology with the targeted therapies, immunotherapy, but in other diseases, cardiovascular disease, infectious diseases, COVID-19. Now we know those patients that are going to be severely ill, mutations in IL-6, that can really, as we all know, had a horrible outcome for thousands of individuals. What was really horrible 2-3 years ago shone light on medicine and science, and so biomarker testing has again found its niche outside of just cancer, obesity, cardiovascular disease. Again, if we continue to focus on discovery, of biomarkers, identification of those areas that are enriched in diseases, rare diseases, then we can find more targeted therapies. Minimal side effects. Cost savings is going to be affected in the long run, in the short term and the long run as well. If you know a priori what medication is going to work, what medication is not going to work, you're going to save hours and hours and thousands of dollars of unnecessary costs. So identification of those patients that would respond to one medication versus another is going to be incredibly important. Again, the cost savings at the end, if
Doctor?
Yes, sir.
We're out of time.
Okay, great, thank you.
Maybe somebody will have a question for
Yes.
you. Members, any questions? Okay, we appreciate you being
thank
here
you so
today. I'm
much.
sorry, we just have
No,
an
no,
ambitious agenda.
thank you so
We
much
wanna
for the
get-
opportunity. Thank you.
Thank you. At this time, the chair calls Maggie Moore. I have you as Maggie Moore, and you are here testifying on behalf of yourself, and you are for the bill.
Yes, sir.
All right, please share your testimony.
Thank you, Chairman, and the committee for allowing me to testify today. In May of 2014, my father, Ben Gilmer, was diagnosed with stage 4 non-small cell adenocarcinoma. He was given between 4 and 6 months to live. They offered him traditional chemotherapy and radiation, which my mom had experienced with her father when he was diagnosed with the same disease in 1993. My dad chose to not go that path. He chose to not go that route. And my mom decided that she was not going to take traditional chemo and radiation as the only option and the only answer. He was not necessarily afforded the opportunity for biomarker testing, but my mom pushed. They paid for the testing out of pocket. And by the grace of God, he qualified based off of a mutation that was found due to the biomarker testing. He entered some precision medicine, targeted therapy. He was on a medication that allowed him to walk me down the aisle. Sorry. I'm okay. Thank you. Sorry. Walk me down the aisle and meet his granddaughter. He passed away last year. But we got 8 wonderful years together. And I know that his quality of life and the fact that he got to be with me and meet Poppy is only because of the testing that was done. He was not going to do anything. And I look at my grandfather who didn't have that opportunity 20 years ago, 25 years ago, and I just think about all of the people that are now going to be missing the same opportunity. Many are not in the position to pay for the testing out of pocket. We were very blessed that my parents didn't take no for an answer and that they did whatever they could to fight and continue for his life. But I think it's very important to consider not just the fact that he was able to be here, but that he was able to be here and be with us and be well. So thank you for the opportunity to speak.
Members, any questions for Maggie?
Thanks.
Thank you so much for being here. Appreciate your testimony. At this time, the chair calls Ilana Stromberg. I hope I said that right. Did I do it? Oh, yeah. Hoo-ah. I have you as Ilana Stromberg. You are representing the Happy Lungs Project and yourself, and you are for the bill.
I am for
All
the
right,
bill.
please share your testimony.
Thank you, Chairman and members of the committee, for allowing me to speak to you. And thank you for your testimony. Wow, that's a hard act to follow. In 2019, I was a healthy, never smoker, regular exerciser, organic produce eater, when I was shocked to learn that I had non-small cell lung cancer. Luckily, they could do surgery right away. I did surgery. They hoped it was a cure. Unfortunately, it wasn't. I did chemo and radiation. They hoped for a cure. Unfortunately, a year later, it came back in my liver and my brain. I have 5 children and a huge desire to live. The surgeon met with me for the liver surgery and told me I was inoperable and that I needed to go home. Luckily, my oncologist told him that there was a newly FDA-approved drug that treated the mutation I had, and the only reason we knew I had the mutation was because of biomarker testing. So the surgeon agreed to operate. I now have no evidence of disease, and I'm on a targeted medicine that we hope will keep working for a long time. And this is truly due to biomarker testing. The biomarker testing also prevented them from having to give me a lot of other medicines that would have caused a lot of side effects and would have cost probably an unaffordable amount of money to me and to the insurance company. So it is really from my heart that I'll ask you to support Bill 3188. And I am really available. I live here in Austin, and I'm happy to answer any questions or give you more information on my personal case and that of many others. My family started a foundation to raise money for lung cancer research, so there are lots of other people that I'm now really aware of in my exact situation and millions of children who really need your support on this bill. Thank you for allowing me to speak to you. Thank you.
Members, any questions for Ilana? Thank you so much for being here today.
Thank you.
You're welcome. At this time, the chair calls Mr. James Gray. I figured I'd see you this morning.
Yeah. Thanks for
Very
giving
good.
us issues.
I have you as James Gray, representing the American Cancer Society Cancer Action Network, and you are for the bill.
That's correct.
All right, please share your testimony.
Chairman, members of the committee, thank you for giving this issue so much time. I'll be brief, but I think these stories that you heard really kind of capture why this issue is so important. This is precision medicine. The future of medicine is now, and this legislation will enable that. Just a couple of statistics I think that are important. Of the 62 oncology drugs that have been issued in the last 5 years, 37 of them require a biomarker or recommend a biomarker as part of that regimen. So no longer are biomarkers a luxury. They're really a necessity for cancer patients. And then my organization surveyed both cancer survivors as well as oncology providers. And with cancer survivors, what we found is 29% of cancer survivors are having difficulty getting insurance coverage for biomarker testing and never pursued it because of that challenge. And 66% of oncology providers indicating that getting coverage for biomarker testing is a moderate challenge when they're working with patients and trying to get insurance coverage. So we appreciate the broad support for this bill. We appreciate the leadership of Chairman Bonin and bringing this issue to the committee. And we are a resource and happy to work with you as a committee as you deliberate on this one. So thank you for your time. I'd be happy to answer any questions.
Member, any question for Mr. Gray? Thank you, sir. Appreciate you being here today.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 3188? No, that's okay. If not, the chair recognizes Chairman Bonin to close on his bill.
Yeah, thank you, Mr. Chairman. And just very briefly, I think one of the most remarkable things is when you think about technology in general, and it wasn't that many decades ago that being able to talk to or watch and have a conversation with somebody somewhere else was in the comic books. And now, that's commonplace. And some of the things that are happening in medical science today are things that a previous generation would have just imagined or dreamed about and thought that was fantasy. But no longer is it a dream about the future. It's not a topic only of research. I mean, these are real world changes that are actually happening. And it's changing people's lives and it's making a difference. And when we look for example, a cure for cancer, what we see is the biggest progress is more often made not with a singular strategy, but with multiple incremental improvements that allow people to live longer and to live better. And that's what this legislation is about. And finally, I would point out, this will include ERS, TRS, and Medicaid. So the state is saying, we're in. We're going to do this as well.
It also looks like it includes ERISA. Okay, so this is everybody. And I'm assuming I'm safe in asking you this question because you are the chair of appropriations, but obviously there's a small matter of the fiscal note, which I'm assuming you've accounted.
We'll be okay.
Okay. All right. Member, any questions for Dr. Bonin?
I think Senator Huffman has it on the Senate side, so we can probably work it out.
Yeah, probably so. Okay, great.
I close.
Thank you. The chair withdraws the committee substitute. If there is no objection, House Bill 3188 will be left pending. Is there objection? The chair hears none. House Bill 3188 will be left pending. Let's see here. Okay, at this time, the chair lays out House Bill 1390, and the chair recognizes Representative Shaheen to explain his bill.
Thank you, Chair Oliverson, members of the committee. Last session, we passed HB 2056 by Representative Click, which provided coverage parity for teledentistry, which means the health plan needs to include telehealth when they cover any dentistry services. HB 1390 seeks to expand on this. When insurance companies cover mental health, they need to include the delivery of mental health services via telehealth. During COVID, TDI issued an emergency rule requiring telemedicine care be included for patients with state-regulated insurance plans. This rule included mental health services. So HB 1390 seeks to make the inclusion of mental health services via telemedicine permanent. This is a great opportunity, I think, members, to expand mental health services to our rural areas, some of our other underserved areas. And with that, I'm happy to answer any questions. Reserve my right to close.
Members, any questions for Representative Shaheen? Okay, we'll reserve your right to close, but don't go far. Is there anyone else wishing to testify on, for, or against House Bill 1390? If not, the chair recognizes Representative Shaheen to close on his bill.
Thank you, sir.
This is a lot easier than yesterday, huh?
Yes.
You got 13 to say they're for your bill.
He did. He's got quite a few people for and none against, but nobody wants to.
It happens every once in a while.
Get your family to come up and say
Everyone is being silent today, which is fine, because then we'll just
That's
get
a good
through
thing,
our
right?
bills more quickly.
Most of my bills are non-controversial.
All right. We thank you, sir. And if there's no objection, House Bill 1390 will be left pending. Is there objection? The chair hears none. House Bill 1390 will be left pending. At this time, the chair lays out House Bill 2797 and recognizes Representative Busey to explain his bill.
Thank you, Mr. Chairman and members, for allowing me the privilege to lay out House Bill 2797. This bill would direct certain health plans to cover the laparoscopic removal of uterine fibroids if they cover hysterectomy or myomectomy, also known as open abdomen surgery. Uterine fibroids are extremely common non-cancerous growths that can develop in a woman's uterus during childbearing years. They can cause pain, hormonal fluctuation, heavy menstrual bleeding, and other symptoms. They also may cause premature deliveries or force pregnant women to deliver via C-section. Currently, uterine fibroid removal is only covered through open surgery under most health plans. Laparoscopic removal is minimally invasive for women and offers benefits over conventional open surgery, such as expedited recovery and shorter hospitalization. I want to thank you for hearing this bill. I know we have a few witnesses, just a few, to speak about the benefits of laparoscopic removal. Be able to answer any questions, and I reserve my right to close.
Members, any questions for Representative Busey?
Thank you, Mr. Chair.
All righty, sir. We'll see you in just a couple minutes. We don't have too many folks. We have one registered to testify. The chair calls Shanae Tracy. I think I said that wrong. I'm sorry. Shanae, right? Yep. Sorry. It's the double E got me there. I thought I messed that up.
Normally I'll put the accent on the end.
Yeah, there you go. Got me. I have you as Shanae Tracy. You are here on behalf of Guidestone Financial Resources of the Southern Baptist Convention, and you are respectfully against the bill.
Yeah.
All right, please share your testimony.
Good morning, Chair Oliverson, Representative Busey, and members of the committee. My name is Shanae Tracy, Director of Government Affairs for Guidestone Financial Resources of the Southern Baptist Convention. Guidestone offers health and retirement benefits in the form of self-funded group health plans to churches, mission-sending organizations, and other faith-aligned ministries. Guidestone is recognized as a church benefit board under federal and Texas law. I'm testifying today to respectfully oppose House Bill 2797 because church benefit boards like Guidestone are exempt from Texas Insurance Code, from the ACA in certain respects, and state insurance licensing and solvency requirements under federal law. Church benefit boards like Guidestone have been exempt from the Texas Insurance Code for nearly 4 decades because of the unique plan needs of its faith-based participants. As a substantive matter, Guy Stone understands the importance of the bill as we already provide the coverage for laparoscopic removal of uterine fibroids. We therefore believe the mandate imposed by this bill is unnecessary and further erodes the longstanding Church Benefit Board exemption in Texas law. Additionally, church benefit boards generally should not be included in health insurance-related legislation because each time they are and bills pass, the carefully considered longstanding exemption is eroded. And the more the exemption is eroded, the less church benefit boards will be able to provide unique, comprehensive, value-filled, cost-effective, and faith-based healthcare solutions to their clergy and denominational participants. We asked the committee to protect the exemption for church benefit boards. We reached out to Rep. Busey's office about our concerns, and we hope he will consider working with us. I'm here to answer any questions you might have.
Members, any questions for Ms. Tracy?
All right,
Shanae, thank you for being here today. Appreciate your testimony. Is that right?
Yeah.
Okay. Is there anyone else wishing to testify on, for, or against House Bill 2797? If not, the chair recognizes Representative Busey to close on his bill. I would point out, Representative, that you do have 5 people registered for the bill. They're just not testifying, including the Texas Association of OB-GYNs, the Texas Medical Association, and Everybody Texas. So,
Well, Mr. Chairman, members, I think this is a very important bill that we need to get done. I'm happy to, as always, work with you if we need to look at a few tweaks along the way, but I appreciate you hearing this. It's an important step, and I hope to have y'all support.
all right. Members, any questions for Representative Busey? Oh, yes, Representative Harris.
How will this impact the women in Williamson County?
Well, just like everywhere else in the state, this would be a less invasive surgery to help so many women that need it. And as you and I know, we put Williamson County first.
Amen. Thank you.
Thank you.
All right.
Thank you, Mr. Chair.
Very good. Thank you, sir. If there's no objection, House Bill 2797 will be left pending. Is there objection? The chair hears none. House Bill 2797 will be left pending. At this time, the chair the chair lays out House Bill 601. The chair lays out a complete committee substitute. And the chair recognizes Representative Chair Jeton, to explain his bill.
Thank you, Chairman. Members, I'm here to lay out House Bill 601, which adds language to the insurance code that seeks to create stronger statutory incentives for claims to be paid at fair value by insurance companies upfront and to avoid the need for policyholders to seek outside help to get what they are owed under the policy, and if they do, ensure that they are truly made whole. If an insurance company attempts to settle a claim below fair value, two of the main avenues a policyholder has are to either hire an attorney and file a lawsuit, or they can hire a public insurance adjuster and advocate on their behalf. Current Texas law already recognizes that if a policyholder proves the insurer to not provide fair value of their claim, that is a breach of the policy and violates the Texas Insurance Code. House Bill 601 would serve as a logical continuation of those portions of the Texas Insurance Code. Currently, under Texas law, a public insurance adjuster's fee for service is the responsibility of the policyholder. Even if a public insurance adjuster is able to secure a larger and fair claim for the settlement of the policyholder then has to pay the fee out of their pocket, so they're never truly made whole on their property damage or loss. However, longstanding Texas law, as well as portions of the insurance code, recognizes the value of making policyholders whole in the event that fair value of the claim is not paid to the insurer. This is a critical protection for Texans and recognizes that if a policyholder is forced to seek representation to secure fair value, they are legally owed compensation for seeking representation. HB 601 seeks to reinforce that protection and echo longstanding Texas precedent to make property owners whole following loss covered by their insurance policy. HB 601, consistent with provisions already in the insurance code, would have fee of the public insurer insurance adjuster become the responsibility of the insurance company only if the final claim settlement is larger than the initial claim valuation, which would only occur if the insurance company failed to provide their fair value of the claim, incentivizing carriers to ensure that all claim valuations are done fair value from the beginning. The committee substitute removes the need for a quarter TDI to determine what is substantially less. We are amending that provision so that the claims secured through the use of public insurance adjuster that is higher than the initial claim offered by the insurance company triggers the provision requiring the insurance company to pay the fee and commission of the adjuster. In closing, HB 601 is a good faith attempt to redefine the statutory incentives to provide for better upfront claim settlement offers from the insurance companies who know that if they are below fair value with their offer, they could be on the hook for more. Not only the policyholder hires attorney and wins, but also if the public insurance adjuster is engaged and successful advocates for a higher claim. Happy to answer any questions, otherwise reserve the right to close.
Members, any questions for Chair Deton? Okay, my friend, we'll see you in a little bit. At this time, the chair calls Mr. David Kim.
Good morning, Mr. Chairman, members of the committee. My name is David Kim, and I am a policyholder and a resident of Texas.
I'm sorry, I have you as David Kim.
Yes.
You are representing the American Adjuster Association and yourself.
Yes.
And you are for the bill.
Yes.
All right, please share your testimony.
Okay. So going back again, my name's David Kim. I am a policyholder and a resident of Texas. My profession as a public insurance adjuster is to represent and advocate for other policyholders in Texas regarding their insurance claim, typically after it becomes a dispute. The insurance policy is a promise or a contract of indemnification, right? The policyholder will neither gain a benefit nor be left in financial harm in the event of a covered loss. Whenever they file a claim and they sort of negotiate with their adjuster, oftentimes they're sort of left at this point where they cannot move the claim any further, and they will then retain my services in order to negotiate on their behalf, right? After I'm able to successfully negotiate the settlement to get them the money they need to do all the repairs, they will then be left at a deficit or in financial harm after they pay my fee. So I'm here to testify in favor of House Bill 601 because in the principle of indemnification, a policyholder should not be left in financial harm from the insurance policy. Oftentimes, I'm able to successfully negotiate, and then they have to find a way to cover my fees, which, according to them, is unfair to them. And they don't know what else to do, but without my services, they're not able to then come to that agreement. So I'm here to testify that HB 601 is a way to incentivize carriers to pay a claim, fairly, and if not, if we are then retained, that our fees should be covered.
Okay.
Open to any questions.
Members, any questions for Mr. Kim? David, thank you for being here today. Appreciate your testimony.
Yep.
At this time, the chair calls Mr. Scott Kibbe. I have you as Mr. Scott Kibbe, representing the American Property Casualty Insurance Association, and you are respectfully against the bill.
That's correct.
All right, please share your testimony.
Thank you, Mr. Chairman, members. Again, today, respectfully testifying in opposition to House Bill 601. We agree that insurers have a responsibility to make a fair offer, but there are reasons sometimes a lower amount initially may be offered. For example, part of a claim may not have been substantiated at the time the offer was made, and a higher amount may be merited following more documentation being provided, whether by a public adjuster or the policyholders themselves. We're also concerned that the bill is rather vague in what should be considered compelling a policyholder to retain a public adjuster. What documentation was received that resulted in a higher amount, and how was the policyholder compelled? Part of that is the fact that we just haven't seen this done in any other state, anything like this. Finally, we're concerned that requiring an insurer to pay the adjuster's commission could have unintended consequences. Most public adjusters do a good job, and our members work well with them. But you could have an adjuster, you could give an adjuster who's writing their own estimate of repairs for the loss an incentive to create a dispute with an unreasonably high estimate. And any additional costs that this leads to are ultimately paid by policyholders. So thank you for allowing me to speak today. Happy to answer any questions.
Okay. Members, any questions for Mr. Kibbe? Scott, thank you for being here today. Appreciate you. At this time, the chair calls Dr. Kevin Lewis. Chair calls Kevin Lewis. Okay, we'll mark Kevin as did not testify. Chair calls Mr. John Schnauz. I have you as John Schnauz, representing the National Association of Mutual Insurance Companies, and you are respectfully against the bill.
All correct.
All right, please share your testimony.
Thank you, Mr. Chairman. So the bill would require, I think this is clear, but just to clarify, the bill would require insurers to pay a public adjuster's, I guess I would say an additional commission under certain circumstances. And as Scott said, I'm not aware of any other state that has a law like this. Something similar proposed in Colorado last year that did not pass. So the current regulation of public adjuster fees, the amount is limited to 10% of the insurance settlement, and that's in Section 104 of the applicable code. This bill would require insurers to pay some sort of commission, but it's apparently in excess of that amount, and the bill is not completely clear on that point, but it says notwithstanding any other fees, the insurer also has to pay them. I'm not sure if that means 10% or something else, but it's a little bit unclear. I guess I would also just direct the committee's attention, it's in the bill, to the other conditions that are already unfair claims settlement practices under the law. One of those that's right on point is the failure to offer a fair and equitable settlement when liability is reasonably clear. That's already something that under Chapter 542 an insurer faces consequences for not doing. So I'm not really sure what this bill is going to add to that, other than our concern is it's going to open up an opportunity for some public adjusters to work on contingency and shift their fees. I would also say, I think Scott made this point, but just to clarify it, with the committee substitute removing substantially, the bill actually creates sort of a perverse incentive for the insurer not to offer more, even if they think it's justified potentially, within the realm of disagreement on the bill, because when they do that, then they're also going to have to pay the public adjuster's fee under the shifting in the bill, and that's may work against the intent of the bill, I would assume. I also want to point out another sort of confusing drafting issue in the bill. The fee shifting is based on compelling the policyholder to hire a public adjuster, whatever exactly that would mean, or a violation of Chapter 541. I don't really understand why a violation of Chapter 541 would have any particular relevance to having to hire a public adjuster. The same provision is not in the law for attorneys, I don't think, so it's confusing implication there. And then the final point, sorry to be a broken record on this, I feel like I say it every week, but just to make it abundantly clear, Texas is a very tight and also a very expensive market already on the homeowner side. The NAIC numbers from the end of last year, we are the 8th least profitable state for private insurers and homeowners for the last 5 years. And so first, I don't think that's indicative of insurers generally being stingy on claims. And second, whatever additional costs this would add, unfortunately, I think would be reflected in upward rate pressure. So happy to answer any questions.
Members, any questions for Mr. Schnauz? All right, John, we appreciate your testimony. Thanks for being here. At this time, the chair calls Hunter Klein. And I have you as Hunter Klein, representing Green, Klein, Wood, and Jones, and yourself, and you are for the bill.
That's correct.
All right, please share your testimony.
Well, first off, thank you so much for hearing me this morning. I must apologize in my ignorance. This is my first time testifying before a committee. I was not aware of the walk-up music requirement. So if I could respectfully reserve Dirty Deeds Done Dirt Cheap by AC/DC.
Right, so we've got a lot of AC
for the next time I come up
here today.
My name is Hunter Klein. My firm, Green, Klein, Wood & Jones, like Mr. Reisner, from whom you heard testimony earlier, focuses on representing policyholders against insurance companies and typically complex losses. I've been doing this for 10 years now. I carry licenses in 2 states, both Texas and Florida, as well as am admitted in federal courts in numerous jurisdictions. In late December 2022, in what I can best describe as a shrouded session, the legislature in the state of Florida passed a draconian measure. And that draconian bill that they passed gutted consumer protections for Florida property owners. You might be wondering, well, we're in Texas. What does that have to do with anything? And it has to do with this. This bill simply is a carryover from protections that already exist under the insurance code and adds to those protections. This bill serves to ensure that Texas property owners have rights against insurance companies. This bill serves to preserve the rights that property owners have against insurance companies, and it incentivizes insurance companies to pay claims timely and fairly. Concerns were raised earlier by learned counsel and advocates on behalf of the insurance industry talking about the risk of public adjusters increasing their estimates in an attempt to increase claim amounts and get their commissions paid. Well, if fair value were offered, that wouldn't be a concern. And if a public adjuster was improperly inflating their estimates, that's not fair value, and the bill wouldn't apply to that. The bill before you serves to ensure that public adjusters who serve a vital role for claims adjustments are properly compensated, and more importantly, serves to ensure that property owners in the state of Texas have rights, and serves to ensure that if you have a covered loss, the insurance policy that you have paid good money for serves to make you whole after that loss in accordance with the contract. I thank you for your kind consideration. I'd now like to answer any questions that you might have.
Members, any questions for Mr. Klein? My only question to you is, do you think it's a good idea for an attorney to have dirty deeds done dirt cheap as walk-up music? Because I'm not sure that sends a positive message for the legal profession.
I respectfully decline to answer the question.
All right. Well, we appreciate you being here today. Thank you for your testimony.
Thank you, Chair.
All right. Is there anyone else wishing to testify on, for, or against House Bill 601? If not, the chair recognizes Chairman Jeton to close on his bill.
Thank you, Chair. Members, I appreciate all the testimony that was given and the opportunity to share this bill. I believe as Texans, we don't often have to deal with insurance companies, but when we do, and we don't feel like we're being treated fairly, that we have the opportunity to hire a public adjuster, that if we are proven right and there is a correction made, that there's reimbursement from the insurer for those costs. And so appreciate the opportunity. Willing to answer any questions. Otherwise, I close.
Members, any questions for Chair Jeton? All right. We appreciate you bringing this. The chair withdraws the committee substitute. If there's no objection, House Bill 601 will be left pending. Is there objection? The chair hears none. House Bill 601 will be left pending. At this time, the chair lays out House Bill 1498. The chair lays out a complete committee substitute, and the chair recognizes Representative Guerra to explain his bill. Did your leg fall asleep there, Mike?
Well, no. I not only broke it, but I also had a knee replacement a while back.
That's right.
Every once in a while it gives me a problem. Anyways, thank you, Chairman and members, for allowing me to lay out the committee substitute for House Bill 1498. I'd like to give some background and context to this legislation. Two elderly constituents in my district reached out to my office because they were surprised to learn that their $10,000 per individual life insurance policy had drained to less than $2,000 because of an automatic loan provision clause in the policy. An automatic premium loan provision in a life insurance policy is a policy provision that allows the insurer to deduct the amount of an outstanding premium from the value of the policy when the premium is due and had not been paid. And I think y'all have a copy of it here. It's small font. The payment is structured as a policy loan, so it also requires interest payments. When a consumer misses a premium payment, not only do they need to make the late payment on the premium, plus a late fee, they also have to pay the interest on the loan, or else it keeps accruing interest. This is confusing, especially for the elderly individuals, and especially to people not in the insurance business. I'm a lawyer, and even sometimes I find some of these provisions a bit confusing. Even my staff struggled when we were trying to figure out this provision when helping our constituents and folks. If you'll look at the handout I provided you, you'll see that out of an 18-page insurance policy, there are 2 short paragraphs, smaller font, that define an automatic loan provision and 1 small checkbox on the enrollment form to select an automatic loan provision for your loan. So I ask you, do you think these constituents understood what the loan provision was or that they had selected it? I know they did not, because when they went to cash their policy in to pay for some end of the life planning expenses, that's when they realized their $10,000 policies had fallen to less than $2,000 apiece because of the premium loan provision. Folks, this isn't right. It just ain't, as they say back home, this is ain't right. My bill simply asks agents to put an automatic loan provision on a separate piece of paper in at least a 16-point font that the agent has to read aloud to the consumer and records that the consumer was read the disclosure. I don't think that's asking for too much. The committee sub provides the Texas Department of Insurance rulemaking authority and articulates that if the original documents were in a language other than English, this disclosure must be also. Now, this is especially important not only in the Rio Grande Valley, but in other parts of Texas. If the original document is in Spanish, the automatic loan provision should also be in Spanish. Up to 5 million older Americans are subject to financial abuse every year. The annual loss by victims of financial abuse is estimated to be at $36.5 billion every year. People oppose this bill might argue that printing a separate piece of paper and reading a section aloud is too difficult to add to their business model. I will remind you, my constituents had an 18-page policy. How is it 19 pages suddenly was too much of a burden? And you can see the paragraph that describes the loan provision. It took me 2 minutes to read it aloud. How about you? I believe that an extra page and two more minutes is an acceptable addition to the current policy to prevent elderly constituents from misunderstanding a provision of their policy and losing almost $20,000. I hope you also feel the same way, members, and I'm happy to answer any questions. And Chairman, members, I respectfully request the right to close.
Members, any questions for Representative Guerra? We will most certainly reserve your right to close, my friend.
Thank you.
At this time, the chair calls Ms. Jennifer Cawley.
Good morning, members. My name is Jennifer Cawley. I'm with the Texas Association of Life and Health Insurers, respectfully testifying in opposition to the bill. Our main concern is not about an extra piece of paper or reading something aloud. What I wanted to point out is that current law already requires that in a situation like this, when someone misses their premium payment and the automatic loan provision kicks in, we are required to send a letter to the insured at that time. An insurance policy can be taken out 10, 20 years before one of these provisions is going to kick in. So I completely agree that a constituent may forget that they checked the box about this automatic loan premium payment. This is a very important part of a person's financial security. So we send a letter that says, you've missed your premium payment. There is a 30-day grace period, again, because life insurance is so important. So that provision is already in the law, as well as a requirement that in a policy like this, that's a whole life policy that builds up cash value, we send an annual statement to our insureds that says, this is how much is in your life insurance policy. This is what your loan provisions are. If you've already taken a loan, this is what that looks like. So again, we are certainly not against transparency. We just wanted to point out that there are real-time things that happen when a person misses a premium payment, when an automatic loan provision kicks in. And I'm happy to answer any questions.
All right, Jennifer, I got a couple of questions for you, and this is one of those issues. When Representative Guerra brought this to me and explained the situation, this almost seems respectfully like payday lending within a insurance policy. How common are these APL things?
Well, they're pretty common because it's there to make sure that if a person, say, goes into the hospital, they're in the hospital for a month, 2 months, and they miss a premium payment on their life insurance policy, that life insurance policy will stay in effect. So you take the premium payment after 30 days, take the premium payment from the cash that's built up, and yes, it is a loan provision for sure.
So is it being charged interest then?
Yes, it is. There is
How do you get rid of the interest? You have to make an extra premium payment?
You just like any type of interest, you pay the loan amount plus the interest that's due.
And what's the interest rate?
It's stated in the policy.
But, I mean, what are we talking, like prime plus a couple of points, or are we talking 22% like a credit card, or what are we talking?
No, it's generally just a normal event, a normal amount, but I'm happy to provide you with that information.
Yeah, I mean, it's kind of the first I'm hearing of this, and I don't know why this hadn't crossed my radar screen earlier, but, I mean, are these opt-in things? Does somebody have to actually, does it have to be explained to them that you understand you're going to get charged interest for this?
Right.
And you'll literally have to make an extra payment in order to get out from under this, otherwise you're forever accruing interest, which is eating away at the principal value of your policy?
Yes. Yes, that is clearly stated in the insurance policy in the contract and when you're working with an agent. But it's not that you have to make an extra payment. It is that you have to pay the premium payment plus if the loan has been taken out,
Plus all the interest.
any interest that is accrued. Yes.
Mr. Chairman.
Okay. I really don't like this, but okay. So I think we had Representative Perez and then Representative Johnson. So Representative Perez.
Thank you, Mr. Chairman. So as Representative Guerra was talking, so these letters that you send out after they miss their payment, if it's a Spanish language, do you send that letter out in Spanish? Because one of the biggest problems I have is your normal, average, everyday person trying to understand whatever notices you send, because you almost need a PhD in insurance to read some of these policies. And
right, absolutely.
This would, so how do you send them? In different languages, or?
I would have to find, I need to find out about that, as a matter of fact. I do know that when I talked to one of my life insurance companies based out in Fort Worth about how this works, they also, and I think a lot of our insurance companies do this, contact the agent that sold the policy to say, hey, your client has missed a payment, and often, like if they miss several payments, is there something wrong? Want to make sure that that agent who has the relationship with the person can reach out to them as well.
Representative Johnson of Dallas.
I want to make sure I understand, because I, like the chairman, I don't think I appreciated the application of it against a cash accrual in a whole life policy. So if you have a $1 million whole life policy, the way that works is you put in premium, it gets a portion of that is invested in the market, it accrues a cash balance. And that cash balance can be used to offset annual premium, correct?
Right.
And so in those situations, then that cash balance would not be charged interest because they didn't check this auto payment loan box. Because
a loan is only taken if the box is checked that, yes, I want an automatic loan payment.
So this would apply when there is
I was assuming, I guess it may be incorrectly, that this automatic premium loan would kick in when there wasn't sufficient cash balance to accommodate the premium. But if there is sufficient cash balance, that's the insured's money that their policy is earned for them. And then they're being required to pay interest against assessing that balance under these provisions. Is that right?
Yes.
That's right.
Yep, that is.
That's insane.
Well,
I mean, because if you have an interest provision, I mean, if you have a cash balance, then that's the insured's money that they should be able to access to pay their insurance premium without being charged an interest penalty for using their own money.
well, that's how it works, and that's in the law. That's been in the law for a long time. That I wasn't around when that was put in, but yes, that is how they work.
And is this a standard provision on all whole life policies?
The option for a consumer to have their premium payment paid from the corpus, yes, that is an option.
Yeah. But but this is different when you say I'm going to use my cash balance to pay my premium versus I'm going to trigger a loan against my premium, a loan against my cash balance.
That is the option. It is an automatic loan payment from your corpus. There's no other option of if you don't pay your premium, and this is designed to be a consumer protection for if you don't pay your premium, it will keep your life insurance in force. Because if you don't pay your life insurance policy, that is the only way a policy can be canceled, is if it's not paid.
Right. No, I understand that. But my question is, it's a little bit different. If you have accumulated, let's say in your cash balance, you've accumulated, in my example, say you have $1 million whole life policy, you've accumulated $100,000 of cash value. So now your death benefit is actually 1.1 because you have the policy value plus your cash value benefit on top of that. What you're telling us is that an insured can't just use that cash balance to fund premium for a period of years. That's not an option. The only trigger is to do this interest loan thing against your cash balance.
Yes, that is correct. Yep.
I think we should look at that, Mr. Chairman.
Okay. So,
thank you.
And I appreciate that. Thank you, Representative Johnson. So, okay, so I'm just been thinking about this as y'all been talking. And I guess what I want to know is, so on a credit card, there's federal law requiring truth and, transparency, disclosure requirements so that a consumer who, I think from what I'm hearing and what I've heard from the author, there could be language barriers and other things at play here. Are there similar requirements when you send a letter out? Does it clearly state how much the consumer has to send in terms of an extra payment to make the whole provision go away? Is that clearly articulated in a big box like it does on your credit card payoff statement? If you make the minimum payment, you will pay this off in 100 million years, and here's how much interest you will pay.
Yeah, there are regulations around how that information is communicated.
I think it'd be helpful if we could, as committee members, see copies of some of the documentation just to verify that, because what I'm worried about is a situation where a consumer misses a payment, maybe they were busy, maybe their spouse is in the hospital, they don't miss the next quarterly payment or monthly payment, and they just keep right on trucking, and they don't realize that one payment that they missed is literally sucking the lifeblood out of their policy via compounding interest over time. And they don't realize this is an ongoing issue because they haven't dealt with it. It's almost like a tumor or something, It's just sort of growing silently, and you don't even realize it. I'm just concerned that could be a situation where a consumer, particularly somebody where English is not their first language, maybe they have limited education. I understand what the policy language says, but I think it is kind of dense.
Yeah. No,
Obviously,
and
depends
again.
on the agent to explain it, which might have been 20 years ago.
Right.
Right?
Well, and again, it's,
You see where I'm going? I just want to make
Absolutely,
sure
and-
nobody's, like,
yeah,
if somebody's
yeah.
like, yeah, hey, cool, that's great. I take the loan all day long. I'll get around to paying it off when I get around to paying it off.
Yeah.
And if I don't, fine. Great. But if somebody doesn't know,
Yeah, absolutely.
gets hammered.
And my point is that every time we send a letter, so we are, attempting to communicate.
Okay.
Every year, there is an annual statement that is sent with this information. But again,
love to
it's-
see
it's-
copies of that. If you could provide us
Absolutely.
examples, just so we could kind of assess the degree to which that's consumer friendly.
Yeah, as I've always said, we're here to provide, life insurance and financial security. We're not, in the business of trying to hide the
Right.
ball. So appreciate
agree.
that and working with you guys.
Okay,
Thank
all right.
you.
Thank you, Jennifer.
Thank you.
Appreciate your testimony today. Is there anyone else wishing to testify on, for, or against House Bill 1498? If not, the chair recognizes Representative Guerra to close on his bill.
Members, I appreciate your patience in listening to the testimony and, of course, the layout of the bill. But I will comment in that I thought it was interesting that the witness made reference to, as an example, if you're in the hospital.
That's all right.
The last time I was in the hospital, I didn't know what was going on. So I just thought that was kind of interesting. And to be hit with something like this, and that size, I find incredulous. Anyways, members, I don't need to belabor the point anymore. I think you get the concern, and now let's just be fair to Texans and make sure everybody understands exactly what it is they were signing, even if they don't understand it. So anyways, thank you very much. And with that, I close, Chairman.
Thank you, Representative Guerra. We appreciate you bringing this bill to us, and we certainly got an education on this, so we'll be following up.
Thank you.
The chair withdraws the committee substitute. If there is no objection, House Bill 601 will be left pending. Is there objection? Chair hears none. House Bill 601 will be left pending. The chair moves that the committee stand in recess until final adjournment recess of the House or during bill referral if permission is granted. Is there objection? Hearing none, the motion prevails. The committee stands in recess.